Maybe taken up again. Yes, Make resolution. Document item 9, I find the review particulars. Number. I'm praying for calling for the. Time for having them. Wait at the same time. Has been submitted by action that a review application have been filed against the judgment and obligated and provide asking so and so. The said review application has been numbered as review petition. It will follow 56. It is found that the said review application has been connected with the business matter again on 12th of 19th of May 2006. Along with the review public.
May I please your lordship? May I please your lordship? I'm appearing for the Canara Bank on behalf of M. Sharma lordship. He is not well since yesterday lordship. I'm really other day your lordship had already.
The rate petition, all policy has been taken by the rate petition. And that policy has been thereafter the Canada Bank, the represented by the M. Sharma, has asked against that they had taken loan by taking that policy at odd grade. They had taken a loan, rate petition. So that information, when we received that information, we looked at the matter, we found that the rate petitioner had taken another loan from the LIC also, 13 lakhs, and that was of 4 lakhs to 5,000. But they are claiming that was the purported assignment, and the person who has taken the loan, not by him, some another person. Thereafter, inquiry has been made, Lordship, and it was found that the loan which he is talking about, the Canada Bank is talking about, there is no such loan has been sanctioned by the LIC. And regarding the LIC, the loan about the LIC, Lordship, we had made an inquiry and we have found that from the account where we deposited the amount, that is confirmed by the central bank that is the account of the writ petition. But we had made it thereafter we had made further inquiry and found some persons, LIC person, guilty of that, and we recovered that 13 lakhs from them. If Rashid takes my last affidavit and as per your order, Rashid may say here, what is the position of payment? And let me take maturity amount against that policy. So you're willing to pay them? We are willing to pay because we have nothing to say about that, but we have found that the what he is claiming
Assignment was false.
the assignment is false and fault. It is
Not to. Yeah, Mr. M. Sherman.
Already been hard, he was already been hard several occasions, but the lordship.
Actually, my lord, on last occasion, your lordship had expressed mind that his presence may not be required because we are not claiming anything against the Canara Bank. Our claim was on,
It is who is going to pay. Any otherwise close it.
Yes, lordship. Only that part maybe.
Maybe have to speak because he.
page 107. The second affidavit by the LIC,
Okay.
107.
You say that these are the things which have been found out. But you are willing to give it to them.
Yes.
Okay. I have you mentioned.
That's particular. No, that was not mentioned, lordships, but
I think the most pertinent thing to be mentioned.
we are ready to, lordships, give, we are willing to pay that because we have already reported, but only the portions, what 13 lakhs, what the loan has been taken against this policy, lordships, that 13 lakhs has been confirmed that that account is of the wheat petitioners. Let us confirm, lordship, if take the time, earlier affidavit in opposition I filed.
So that 13 lakhs have been received by the police.
No,
13 lakhs to be deducted from him. From
no,
the
my
picture.
lord, that I'll not agree. I have not taken any.
But you have found that the policy holder is the. We had no quarrel with that. There were some officials from LIC who used the policy for the purpose of taking out some amount of this 13 lakhs. And thereby an FIR had been filed and a final report. But the amount of this 13 lakh, which was taken out on the basis of the use of the policy of the petitioner by your officials, was that amount of 13 lakhs deposited to the petitioner's account?
No, my
Yes,
lord,
yes.
no, their affidavit, page number 6, my lord.
I may take
Earlier affidavit,
earlier.
yes, page 5 it begins.
Page 5. By
I don't know what is the running page.
Running page would be That time perhaps this system was not there.
Page 5.
Page 5. And Lordship, page 6, the first line, account was credited to the bank account of one Tushar Kanti Das. They themselves are saying that this
That is the later part.
later
Later part.
after
That is withdrawn part.
further
That is the
inquiry,
withdrawn part. From this account, the Tushar Kanti Das has withdrawn that amount. So that is not the, kindly come the page 5 Lorships from beginning. What is the facts? That is the page 5.
Paragraph.
paragraph 7
Paragraph 7.
starts from page 4.
That with
Start
regard
from
to the
page 4.
statements in para 4, the deponent states that the alleged fraud came to the knowledge of LIC after receipt of a letter from Canara Bank when Joy received from Canara Bank claiming the issue of the the initiative was one of the police. The reason was clearly bank account of you. What do you say about this? The loan amount of rupees so and so to Ashutosh Chaudhary so and so maintained in Central Bank of India.
That account also is forgement. This is not my account. I have stated in my
Further inquiry with the Central Bank Authority regarding the account of so and so, it was confirmed that the senior manager was there that the account holder of the said account was so and so. And the amount that was credited to the account of so and so. Later, after further inquiry with the central, it was informed that the amount was debited on demand from the above account and credited to the bank account of one Tushar Kanti Das so and so. So this loan of 13 lakhs was given by LIC
Petition.
to the petitioner. Now this account is forged or not? How do I know?
These accounts, as per the central bank Lorships, they, as per their instruction, that is the of the petitioner. As your Lorships seen, Lordship, and the document we have also annexed Lorships as C and D.
Actually,
Loan payment Lorships.
what is actually?
Lordship, annexure A is the Lordship, this is the account, central bank Lorships. This is the account, what is of the petitioner Lorships. And the annexure B, Lordship, the manager's letter. Lordship. Annexure. This is issued by senior manager Lorships on the central bank.
So that amount has been received by the petitioner.
no man. I have denied that in my rejoinder affidavit.
What do you say?
Page 46, I have answered that. And page 46. Running page 46.
Where?
Paragraph 5. The stand of the respondent number 5 in the incident petition that they have sanctioned the loan after due verification of loan submitted by the borrower. In this connection, the petitioner begs to
Is
state the
this the
connection
photo of yours at page 80,
page.
running page 80? Whose photo is this of Canara Bank?
This photo I have denied, but neither this is my photo. The PAN card also is not my PAN card.
Canara Bank,
This
not
year.
your pen card.
Address is also wrong, man.
Where is your document to which you saying that you
Man.
rejoin the file by the petitioner? You say. Have admitted that a so-called loan amount against which the LIC was allegedly assigned was credited to the bank account of
Page 42, 43.
Madam, what do you say about this particular paragraph 7 of the affidavit filed by respondent number 1 to 4 in your rejoinder?
that the photograph
When the
affixed,
filed by the petitioner,
my lord, as regards paragraph 7, the
page
photograph,
9,
uh,
paragraph 4.
paragraph,
The respondents in so and so have admitted the so-called loan amount to AIA was allegedly assigned and credited to the bank account of the AIA. You have not denied that.
my lord, I have denied in page
Yeah, we
48,
don't find any denial.
page 48, my lord, in my rejoinder affidavit, the signatures.
Page 48. Page 48 is their affidavit filed
My
by one
rejoinder.
Rumi Boru.
My rejoinder.
No, your rejoinder is there. Only one rejoinder is there. What is the reply to your rejoinder at paragraph number 7?
Paragraph 7. The photograph as affixed annexure 1 of it is not the petitioner. Document also reveal that the applicant has submitted PAN card, voter identity card. The affidavit of two documents are not enclosed. The name given in the nominee column there is completely incorrect. Petitioner's wife name is Shukta Chaudhary, who is about 60 years of age. But in my petition, I have given this my PAN card and electricity bill at page 42 and 43.
Should compare 42 of the repetition and annexure A of the central bank passbook. That probably same person.
Huh? Annexure?
Annexure A of my affidavit in opposition. Page 11 lordships. The central bank, that is the issue by the central, that is the account of the central bank.
How do we know?
Check. This is the first page of this account where we had paid the 30 lakhs.
Completely different persons.
This is the photo and the writ petitioner has the writ petitioner. He is claiming that this is the person writ petitioner is. So probably Lordship, the photo is probably the same person.
Completely different photographs, Lordship.
Maybe
Where did you get this document?
from the central bank, Lordship. Central bank itself, Lordship, written to us, Lordship. That is the second page.
Is the central bank a party here?
Party here, they didn't appear.
Mr. M. Sharma appears for the
Kannada
central bank
No, no,
also.
Kannada Bank.
Kannada Bank.
I know that. He also appears for central bank. Don't worry, we'll ask him to be instructed. Let him appear and get hold of this document. That is the only way out for the 13 lakhs. Otherwise, you take this and then fight it out about the other norm.
Well, I'll wait for some more time. Let them take instruction.
Let it come then after some time. In the June.
But we have it on not on Monday. We'll have it on
Lordship,
9th of June. In the meantime, you file your affidavit that you are willing to pay the remaining minus 13. File that affidavit. Because then we
My
get there
statement may
and
also
ask
take-
them to disburse that so that you get the petrol out here, although it is very dear nowadays. And then fight it out for the
my statement
remaining
may also
13
be
lakhs.
I had my statement also be recorded, but we are willing to pay that amount.
So therefore, put it on affidavit. Heard Ms. P. Chakraborty, the learned counsel, appearing on behalf of the petitioner. Mr. A. Kundu appears on behalf of the LICI. So and so appears on behalf of the Canara Bank. The issue involved in the instant petition pertains to not granting the petitioner the proceeds of the policy bearing number. What is the policy number? 49P566060. And the entitlement to the effect of rupees 63 lakhs.
Yes, ma'am.
Entitlement to the amount of rupees 63 lakhs. And where I saw that amount, where is that? Where do I find that 63
Uh,
lakhs?
Page, paragraph 3 of the writ petition.
Huh?
Paragraph 3 of the writ petition.
That is actually mistake of facts, Lorships.
63 lakhs 60.
Oh, that amount may be Lordship, not the correct one, Lordship, correct figure, Lorships.
63 lakhs 66,000.
50,000.
Huh?
Sum assured is 50,000, page 4. 50, sorry, 50 lakhs. Lordship,
But how much is they are entitled to as per you?
Lordship, that correction, that calculation has to be made because bonus will be added to that, Lordship. Some more will be added to that. Lordship. So that
To the amount of rupees 63 lakhs 66,000. Pusto. It is seen from the affidavit, which additional affidavit, which was filed by the affidavit in opposition filed by the branch head, Life Insurance Corporation of India, dated 8/9/2025. That upon making necessary inquiry, it was found that the allegation of assignment by Canara Bank Gauhati branch was an illegal act inasmuch as there was no such assignment made as per the proper record books maintained by the LICI. Mr. Ekundu, the learned counsel appearing on behalf of the respondent LICI, submitted that the amount to which the petitioner is not entitled to on the basis of the policy is less than what has been stated in the writ petition, being less than what has been stated in the writ petition. And it has to be worked out after taking into account the installments so paid, read with the policy terms and conditions, and the bonus payable.
Pension, it was a pension, into 22,000 per month, I was entitled to pension. So that,
As per the terms and conditions, no, that is what I say. He, however, submitted that as would be found from the inquiry made with the central bank, an amount of rupees 13 lakhs was disbursed to the petitioner. And as such, the LICI is willing, has no, LICI is willing to make payment to the petitioner his entitlement after deducting the amount of rupees 13 lakhs. First, it is the opinion of this court that the said aspect be brought on record by filing an affidavit. Mr. A. Kundu, the learned counsel appearing on behalf of the LICI, submits that the said affidavit would be filed on or before 1st of June 2026. This court also duly takes note of the submission by Ms. P. Chakraborty, the learned counsel appearing on behalf of the petitioner, that the petitioner did not and does not have any account maintained with the Central Bank of India, as have been alleged at paragraph number 7 of the affidavit filed by respondent number 5. You are respondent number 5, na? Mister? You are respondent number 5?
No, I am for the 1 to 4. Realize.
Are you sure?
Yes, sir.
But you, what have you done, Miss P. Chakraborty? You have filed a rejoinder putting that in respect to respondent number 5. That is why I was saying, na,
Yes.
you have made a mistake in filing, putting the number. Your affidavit should have been, your rejoinder, therefore, what I was reading, it says something else. Finally, see, the affidavit which have been filed by you, the respondent number 1 to 4, your rejoinder. Finally, see, that is a different rejoinder. See, what is your reply to paragraph number 4? At paragraph number 4. You have made a mistake.
It's against 5 only. I have not.
Then that is why I was submits that the amount that have denied to the statements made in paragraph number 7 filed by the LIC, of the affidavit filed by the LIC, and stated that the photograph mentioned in annexure 1 to the affidavit filed by the respondent numbers 1 to 4 is not the photograph of the petitioner. It is also taken note of that Mr. M. Sharma, who appears on behalf of the Canara Bank, have sought for an accommodation today. On account of certain personal reasons. This court is of the opinion that disposing of the instant writ petition without hearing Mr. M. Sharma, the learned counsel appearing on behalf of the Canara Bank, would not be in the interest of justice. Accordingly, this court fixes the matter on 9/6/2026 at the top of the list for final disposal. Mr. M. Sharma shall ensure, the Canara Bank shall ensure that either Mr. M. Sharma appears on the next date without fail or engages another counsel to represent the Canara Bank. It is clearly mentioned herein. This court further puts the Canara Bank to notice that in the circumstance the Canara Bank is not represented or adjournment is sought for, this court may proceed with the disposal of the writ petition without further hearing the Canara Bank.
Instruction regarding
Central.
Central Bank. Is supposed to take instruction from the central.
I can't do, she can't say anything. She has no rule. Because otherwise, Mr. M. Sharma again won't appear. I know him. And madam, do something with your affidavit. Your affidavits are wrong. And kindly, both of you take the note. What is the running page now?
Right.
Yes, who is asking for time for filing affidavit?
The time matter is coming, madam.
Huh? We've served the purpose just now, I know. Okay. Mr. G. Bush, the learned standing counsel of the Gauhati High Court, has submitted that an affidavit in opposition has been filed today. The said affidavit in opposition, however, is not on record. Mr. R.P. Sharma, the learned senior counsel who appears on behalf of the petitioner, seeks for a short accommodation to go through the said affidavit. Accordingly, list this matter again. Can we have it on 21st? No. Or after that?
21st of this month, madam. Any date.
No, if you want to file a reply, you cannot.
Then, madam, 9th June.
Not no, 11th June. Accordingly, the matter stands directed to be listed again on 11th of June 2026 In the meantime, liberty given to the petitioner to file any reply if so advised on or before 9th of June 2026.
Yeah.
You file your affidavit in the Mr. A. Bhattacharjee appears on behalf of the respondent number 6 and submits that he would file the reply on or before 1st of June 2026. The affidavit in opposition by 1st of June 2026. Petitioner granted liberty to file reply thereagainst on or before 9th of June. Public.
This is the COVID-19 matter.
Did you get those?
Yes. You have also received the record of the DP. Please come in. Some websites are actually down, so I could find this. I have stapled my lord separately the state government, central government, and High Court notifications.
Your period is from
1st of June 2020 to 7th of July. There is another super complex. And apart from this, which is DP2. The earlier one is DP1.
Nothing wrong with you. Why you are putting all the, in a charge, why you are putting that you was in Drunken state and all earlier in 2017? I'm not understanding. Why you are putting B in that? This may be a consideration for at the time of imposition of punishment.
But even otherwise also, not the issue. Just explain. The part charge,
That's preconceived thing.
part charge has been incorporated in the memo of charge of so called, but there was no inquiry done on those allegations.
So you are now taking it, racking up a dead body.
No, the reason for mentioning the past charge and the show cause is that so that the delinquent charge officer get an opportunity that his past charge will be considered at the time of imposing a penalty. Because
So that means you, this is preconceived.
no, it's not.
Obviously, no. You see, when you are trying to find out whether it's a case of gross misconduct or not, so at the time of imposition of you, so you know that we are going to impose the penalty.
No, it's a
This is what has come out from your mouth.
The requirement under the law is that if I am taking into account the past conduct of the charge of employee, I am required to give him a notice or information that look here, your past conduct will be considered. So that requirement is fulfilled by incorporating that thing in the charge sheet. In fact, in Muhammad Yunus Khan, para
These are
34.
judgments to look into by division bench.
Lordship will also have a look.
I won't.
Para 34 of Muhammad Yunus Khan, Honorable Appeals Court said that it can be in the charge sheet or in the form of a notice before imposition of penalty. It's a small parameter.
Government of Assam has imposed a total lockdown of the Kamrup metropolitan area on from 29/6/2020 to 12/7/2020. Whereas the same notice, the government has further directed all the district to promulgate necessary orders for total lockdown of all the municipal and town areas where there whereas the government of Nagaland which was used to promote the spread of contagion and taking note of the safety and well-being of the employees in the future prevention. The 8th meeting within the state of Nagaland shall inform the solicitor the employee residing within the national center. The concerned that employee will be discussed. Employees are expected to inform if any tenant for person to be cases of emergent nature involving personal liberty be pain, demand, cases of request for still the hearing taking. This is a case of imposition of cost for troubling this.
But so far as the period is
we
taken
impose
into
a
account
cost
is
of
concerned,
upon this person concerned. How, there's in the case of sensitivity of low people.
so far as the
This is,
period is,
I've never heard anything like this. Let me,
so far as the period is concerned, your lordship has taken note of, my humble submission is lordship will take a call on that. I'm leaving it to your lordship.
No.
Whether at all that in that period.
you have troubled him. You have not only troubled him with a disciplinary proceeding, you have also troubled him with an appeal also. All these things you have done. It's not done. And what is the punishment imposed? Termination. Huh?
Removal from service.
We pass the judgment in such a manner that we take care of the second disciplinary action also. And say that this is a preconceived mind of the
So far as-
authorities concerned to do all these things.
With all due respect, my lord, so far as view taken by your lordship with regard to your preconceived mind, para
Absolutely
34
clear. Absolutely clear.
para 34 of Yunus Khan.
Yunus Khan is for division bench, not for this
I'm-
one. No, sorry.
It's my duty, my lord. I'm
You have
just
shown it.
placing the law.
You have shown it.
It's not-
I've heard it. Don't worry.
Look, it doesn't amount to preconceived mind.
It is a
That is what I'm
preconceived
trying to
mind.
say.
It is a preconceived. Why on earth you have imposed some increment? In 2000 so and so, 2017, you have imposed a punishment.
Yes,
2018 or 19, you have imposed a punishment.
yes,
After taking into consideration all these things.
yes.
And why you are referring to all these things that he was in a drunken state of affairs in 2017?
Look,
And now you are absent for COVID duty. See,
it is only referred to come to a conclusion with regard to the quantum of punishment.
so therefore my question is, Mr. Das, why on earth on the date of imposition of issuance of a charge sheet, you have come to a finding that we are going to consider your punishment? Isn't it preconceived?
No,
Yes.
Lord,
Let me ask the law.
had it
No, Mr. Da. Let me pass the law at the division bench. You have very good judges in the division bench. They are very good with the high court. They will do it. No, sorry.
my lord, what I
You see, I am giving you a good ground also for challenging. Putting a cost of 1 lakh.
no, my lord. Lordship
Yes.
will kindly appreciate.
No.
Lordship will kindly appreciate para 34. My lord.
I am imposing a cost of 1 lakh.
Lordship will kindly appreciate para 34.
And that should be,
Whether-
that cost
I'm
should
only
be,
the point whether this
and
legal
that
purpose-
cost should be recovered. The Gauhati High Court shall make that payment and shall be recovered from the salary of this inquiry officer as well as this officer concerned. How can they be so inhuman?
may not be, my lord, telling that. May not be.
Absolutely. How
That's
can they
you.
be so inhuman?
May I
Is
just-
it no?
3 lines?
No.
My lord, 3 lines. My lord.
No,
3 lines. Lordship will kindly permit.
no. I'm not going to listen to all this.
It's not a preconceived.
Is it
mind.
a case of, is it a case where it's a case of COVID in
Facts-
Uniscan?
No, facts may be different, my lord.
So that fact is
I'm-
different. Sorry.
I'm not on that. I'm on the proposition that your lordship
Okay,
has
another 1 lakh upon you. You are a new senior advocate, you will be now able. 1 lakh.
My lord will kindly consider this full
Mr.
line.
Das, don't allow me to pass strictures against you any further.
My lord.
I'm going to pass stricture.
So far as period is
No,
concerned, my lord, I
nothing
have
big.
already submitted
disturb
before
this
the
court.
lordships that I am not going into that. So far as
I am
period
now,
is concerned.
I am only going into one thing, simple question, that this is a case for,
Lordship will take a call so far as whether.
I've taken a call.
No.
Mr. Das, on the last occasion, I have looked into this aspect. I have heard this matter. There is nothing. I only asked him to point out this
On
aspect.
the last occasion also, I have submitted before lordship that I am not I am not coming in the way your lordship's taking a decision, my lord, so far as whether at that point of time a show cause could have been issued. to
Mr.
him.
Das, are you just implying before this court that will come in the way for this court to
I'm so
pass an
sorry.
order? Wouldn't that be interfering with the cause of justice? Huh? You are making a submission that it is that to cause an interference to the cause of justice. This is what is your submission now.
That has
It's
been
a very
conveyed.
serious submission.
Sorry. If
Then-
that has been conveyed, I am taking my,
Contempt of court.
lord,
Why shouldn't I refer your name to the Chief Justice for initiating a criminal contempt against you?
withdrawing my
No,
submission.
you are just
That has
making
been
a
conveyed.
submission before this court to the effect that before passing a judgment, you so and so.
No,
Not a before.
Lord, I only want that
Interference with the cause of justice. What is that? Which section?
I'll never do that.
No, you are.
I'll never do that. As far as period is concerned, I am not making any submission. So far as period is concerned, my lord, that your lordship will take a call.
Period? What period?
Within that period, there could have been a show cause or not, my lord, that your lordship will take
Yeah.
a call. But so far as
This is
the
a case of the insensitive manner in which the proceedings have been initiated against the person concerned.
certainly,
You have to also understand, he's a grade 4
I
employee.
understand. my
Then
lord. My lord, I
you
am
have
on-
not stopped anywhere in doing anything against him.
I am not at
Yes,
all.
you could not. First of all, tell me, no.
Lordship will interfere with the penalty, no problem, my lord.
Not only interfere.
I am only on the
You have to
point.
pay him the entire cost of the entire journey of this litigation. From from filing of his show cause reply till date.
I'll urge upon your
You
lordship.
give him a bill.
I'll
Give him a
urge
bill.
upon your lordship. I'll pray before your lordship
No.
not to, so far as second part
The
is
second-
concerned. So
second
far as
part-
second part is
This
concerned.
there is no second. Now we are going into the third. For this. What is that? Contempt of Court Act 1970. the third part.
May not be inclined. My humble prayer. It's my humble prayer.
Yes.
I
Now,
wanted to show only that four.
this is not done. This is not a case where you have to be. It is the most insensitive
Doctor will take a
thing.
call. Sir,
I have already,
I only sincerely wanted to apprise your lordships with that particular paragraph, wherein, my lord, the propositional law has been settled that even if it's the delinquent charge officer has to be informed in the charge sheet or a show cause before imposing penalty. That much only, my lord, nothing else.
Mr. Das, do you think that this court is not aware with that law? This is at a time when you are imposing upon him the penalty after giving him the inquiry report. This is the law that at the time of imposition of penalty, you have to inform him that these has been your precedents, these are your conduct, and being your conduct in all these things, now therefore, why we should not take any action against you for so and so, punishment of removal from service or something. This is what you have to inform. That is the law.
Correct.
And but not at the time of a charge sheet being issued, wherein you have already formulated a mind that we are going to impose him the penalty before the inquiry officer proceeds to decide as to whether it is a case of gross negligence or gross misconduct or not. That is the principle. And let me put that principle or clarify that principle in my judgment, and so that what happens next is let the division bench say that, okay, I am wrong to that effect, and let the division bench look into it. But the fact remains that a grade 4 employee has been tortured, humiliated, put out of service. Let me pass on. Heard Mr. So-and-so appearing on behalf of Mr. H.K. Das, senior counsel. Appears on behalf of the respondent number 2, 3, and 4. Mr. K. Gogoi, you appear for Judicial Department? Mr. K. Gogoi appears on behalf of the learned additional senior government advocate, appears on behalf of the respondent number 1, Milady. Huh? Up to 1. Yes, Mr. K. Gogoi, what do you say on this principle? The third part, that leave it to me, what I am going to do. I'm not on that. As regards the first part too, it is a very insensitive, but I'm not on that. My question, he's the show cause notice, which is to be issued. It's not only that, it is not predetermined. Means if you are thinking that at that issuance of a show cause, if you are thinking to inquire into that these are the things which are there, and these have happened earlier, and therefore this is there. Now, is it required at that time or is it required after the inquiry report? Inquiry report, that is the law. The instant repetition. The petitioner herein has filed the instant repetition being agreed by the removal order being number CJM CHA 597-01 2024 dated 5/3/2024 passed by the learned Chief Judicial Magistrate Authorised, as well as the order dated 19/7/2025 passed by the learned appellate authority come district judge Authorised in appeal against the disciplinary proceeding case number 1/2024. The brief facts which led to the filing of the instant proceeding are COVID-19 next. COVID-19. Pandemic spread across the world sometime in the month of March 2020. In the middle of March 2020, in order to prevent the spread of COVID-19, the government of India, in the Ministry of Home Affairs, the government of India, in the Ministry of Health and Family Welfare, and the Ministry of Home Affairs, as well as the Ministry of and Government of, and as well as the Ministry of Health and Family Welfare, passed various directions curbing the movement of the people. In a manner unforeseen. The Assam State Disaster Management Authority had also passed various directions. It may not be out of place to mention that at that relevant point of time, if a person is seen wandering in the streets, the person is either arrested, the person is arrested by invoking the powers under Section 188 of the Indian Penal Code. A person sneezing or having a fever is put in containment zones. It is not out of place also to observe that a person, if affected by the COVID-19 virus, a stigma is attached to him. A stigma is not only attached to him, but to his entire family. In the backdrop of the above, it is pertinent to take note of that all courts were shut down by orders passed by the Gauhati High Court in the state. All courts were shut down. All courts within the jurisdiction of the Gauhati High Court were shut down. However, sometime later, in the month of April 2020, May 2020, on account of situations requiring urgent matters to be heard, extreme urgent matters to be heard, Some courts function with a staggered roster. It may not also be out of place to take note of that the Supreme Court also in WPC Sumoto 1/2020 passed various orders relaxing the period of limitation and taking into account the difficulties which a litigant would face. The petitioner, whose native village was about 21 kilometers from the court premises, the petitioner, who was working as a grade 4 employee, has his native village situated 21 kilometers from the office. The petitioner, during the say COVID period, went to his native village at Adabari Setia ending down. And could not return on account of the various restrictions imposed by the COVID pandemic. The petitioners, however, it is seen from the affidavit in opposition filed by the respondents, number 2, 3, and 4, that for the period from 1/6/2020 to 6/7/2020, the petitioner was put in the staggered roster, and more particularly in Group B, by an order dated 30/5/2020. The petitioner could not attend on account of on account of there being no public transportation available, and the fact that the petitioner did not have a private vehicle of his own. Be that as it may, on the petitioner on nine 7/2020 would attend his office. On that day, a show cause notice was issued by the Chief Judicial Magistrate dated 6/7/2020, alleging inter alia that the petitioner was absent from his office since 1/6/2020 till 6/7/2020, excluding the derostered days. Which was in utter defiance to the which acted an act of insubordination and remaining absent unauthorized. In addition to that, in the said show cause notice, the petitioner was also informed that on earlier occasions, there were two departmental proceedings wherein the petitioner had given written assurance that he would not be unauthorizedly absent in future. The petitioner was asked to submit a reply within 7 days from the date of receipt of the said communication. On the date on which the petitioner joined back on 9/7/2020, the petitioner was handed over the said show cause notice. A reply thereagainst was filed on 15/7/2020 by the petitioner, wherein he had categorically mentioned that the petitioner went to his native village, which was 21 kilometers from Sipsagar town. The petitioner further stated that he had neither a bike nor public transportation was available. It was also categorically mentioned in the said show cause reply that on account of the COVID-19 pandemic and the lockdown declared by the government, he could not attend duty from his backward village to Sipsagar. The petitioner also stated that though he had given a written assurance that he would be regular in service, but on account of the COVID-19 pandemic, he could not attend. The respondent authorities, however, was not satisfied with the reply, and thereupon issued a show cause charge sheet on 28th of July 2020. A perusal of the said charge sheet would show that the charge upon the petitioner, though primarily was of unauthorized leave with effect, unauthorizedly being absent with effect from 1/6/2020 to 6/7/2020, excluding the derostered day. But in the very charge, it was also mentioned that sometime in the year 2017 and 2018, the petitioner was absent, was unauthorizedly absent, and resultantly, there has been 2 punishments imposed upon the petitioner. It appears from the very charge which have been framed against the petitioner that the concerned respondent authorities have already taken a view that the petitioner was already punished in the year 2017 as well as in the year 2018. And under such circumstances, the unauthorized absence of the petitioner with effect from 1/6/2020 to 6/7/2020 was an act of insubordination and remaining absent unauthorizedly. To the Sarchit, the list of documents which you have enclosed is also of relevance in as much as the list of documents included where number one, attendance register, number two, show cause letter dated 6/7/2020, number three, reply dated 15/7/2020 to show cause letter. Number four, documents relevant to disciplinary inquiry proceedings dated 1/2/2018. And number five, documents relevant to disciplinary proceeding inquiry report dated 21/12/2018. It therefore prima facie appears that the respondents were all that the basis on which the petitioner was being charged was on the basis that there were already two punishments imposed in disciplinary proceeding in the two earlier disciplinary proceedings. The petitioner submitted a charge on 10/8/2020. Stating inter alia the reason why the petitioner could not attend on with effect from during the derostered dates during the period from 1/6/2020 to 6/7/2020. Stating inter alia that he went to his native village situated at Adabari Setia and Gaon, which was situated about 21 kilometers away from Sibsagar. And there was no public vehicle and public transport which were flying due to the ban imposed by the concerned government. And due to communication inconvenience, he could not attend the office. If the petitioner also stated that in respect to the earlier departmental proceeding, the petitioner has already been punished by imposing the punishment of one annual increment without cumulative effect in the first inquiry proceedings and one and two increment was withheld with cumulative effect for 2 years in the second departmental proceedings. The petitioner, a further perusal of the reply of the petitioner shows The petitioner pleaded with folded hands to duly take note of the reason why he could not attend his office. The record reveals that the inquiry officer was appointed who was the then SDJ M. Toraido. Evidence on record which is seen in the said departmental proceedings enclosed as Annexure 5. The evidence which was recorded in the said departmental examination have been enclosed collectively as Annexure 5 to the petition. Annexure 5 and 6.
It's the re-examination.
Annexure 5 to the writ petition. A perusal of this evidence which have been adduced by the on behalf of the department to show that apart from the documents which were submitted, which were furnished to the petition, along with the charge sheet as referred to herein above, in pursuance to Rule 9, bracket 2 of the Assam Discipline and Appeal Rules, Assam Services Discipline and Appeal Rules 1964, for short, the rules of 1964. There were further more evidence led, documentary evidence led. The inquiry officer thereupon submitted an inquiry report dated 2/1/2024, dated 19/12/2023. Yeah. It's very pertinent to take note of that a perusal of the said inquiry report also shows more particularly under the subheading B, what were the charges which were framed against the petitioner? The charges at Roman 2, Roman 3, Roman 4, Roman 3 are in respect to disciplinary proceedings which have already been held, and thereupon punishment already imposed and punishment imposed upon the petitioner. The charges number 1 and 5, however, relates to the allegation as to why, as to the allegation pertaining to insubordination and unauthorized absence from 1/6/2020 to 6/7/2020. This court finds it very pertinent to take note of that the charges 1, Roman 1, Roman 2, Roman 3, and Roman 4 were all taken up together, which included that, meaning thereby that the department, that the inquiry officer appeared to be influenced by the transgressions of the petitioner in the year 2017 and 2018, and the imposition of punishment in the two departmental proceedings. A further perusal of the entire charge sheet, further perusal of the decision in respect to the charges Roman 1, Roman 2, Roman 3, and Roman 4 would show that the inquiry officer did not consider as to whether the petitioner did not consider or even opine as to whether the petitioner was barred by circumstances beyond his control to attend his office from his native village, which was 21 kilometers away from his office. This aspect was not at all addressed by the inquiry officer. On the other hand, what impressed upon the inquiry officer was that during the outbreak of the pandemic COVID-19, the entire Indian government machinery was put in a hold. But then also, the Indian judiciary had showed exemplary characteristic and imparted justice to the poor and needy. And in that perspective, the inquiry officer came to a categorical finding that it was proved beyond all reasonable doubt that the petitioner deliberately remained absent in the roster duty during the month from June 2020 and July 2020 till 6/7/2000 till 16/7/2020. The record reveals that in pursuance to the said inquiry report submitted, the petitioner was granted an opportunity to submit a written statement submit a representation come written statement. The said opportunity so granted by the Chief Judicial Magistrate, Soraido, appears to be in consonance with the settled principles of law to the effect that an opportunity has to be granted before, if an adverse inquiry report is made against the delinquent employee, by providing a copy of the inquiry report in respect to the proposed penalty which the disciplinary authority proposed respect to the penalty which the disciplinary authority proposed to impose. The petitioner submitted a reply dated 2/1/2024, wherein the petitioner pleaded that no imposition of penalty be made inasmuch as it was treated as it may by the order dated 5/3/2024. The petitioner was imposed the penalty of removal from service with immediate effect. it was also mentioned that the petitioner would forfeit his pension and gratuity. Being aggrieved, an appeal was filed by the petitioner under Rule 15 of the Rules of 1964. The said appeal was dismissed by an order dated
19/7.
19/7/2025. It is very pertinent to take note of as to how the the appellate authority, appellate authority considered the defense that the petitioner, on account of being residing at his native village, which was 21 kilometers from his office, could not attend his office due to lack of public transportation. And further, the petitioner did not have a private vehicle on its own. The learned appellate court, appellate authority, at paragraph number 22 of its order, observed that as other employees could attend, there was no justification that the petitioner not to attend, for the petitioner not to attend. It is, however, not out of place to observe that there was no evidence led in the disciplinary proceedings by the department of any person residing outside the town of Sibsagar attending the office during the pandemic. It is under such circumstances the petitioner, being aggrieved, has approached this court by filing the present petition. The record reveals that this court, by the order dated 30/4/2026, by the order dated 19/2/2026, issued notice and directed the respondents to bring on record their stand by filing the affidavit. An affidavit there against have been filed by the petitioner respondents through the district and session judge Soraido. Wherein the facts narrated herein above have been mentioned. And it was further justified. And the punishments to impose upon the petitioner were justified. Further to that, to the said affidavit, the punishments which were imposed to the petitioner earlier have been enclosed to the affidavit. In addition to that, it is also mentioned that during the pendency of the disciplinary proceedings, the petitioner have also another show cause notice was issued on 29/8/2023. by the Chief Judicial Magistrate Soraigao Nari for coming late on various dates. The respondents have also enclosed the roster issued by the Chief Judicial Magistrate, Sitsagar, on 22nd of May 2020 and 30th of May 2020. Let me come back. 1 lakh to this. And I think it should be more because you have to take care of the next discipline. Appearing on behalf of the petitioner submitted that a perusal of the disciplinary proceedings so initiated against the petitioner and more particularly during the period when and more particularly in respect to the charge. So in respect to the charged misconduct was absolutely unreasonable. The learned counsel further submitted that the perusal of the charge sheet as well as the disciplinary as well as the inquiry report would clearly show that the said disciplinary proceedings was initiated with a preconceived mind of imposing penalty upon the petitioner. The learned counsel further submitted that a perusal of the inquiry report also would show that the state inquiry report suffered from perversity in as much as a relevant factor which ought to have been taken into consideration and would have otherwise materially changed the outcome was not taken into consideration. The learned counsel further submitted that the evidence on record, evidence which was taken of the various witnesses nowhere would show that the petitioner, in spite of having the facilities during that period to attend his office from his native village, did not attend. The learned counsel further submitted that in order to be that an absence in order to be unauthorized has also to be willful. And when the petitioner would not attend for circumstances beyond his control, there cannot be a case of willful abstention from duty. The learned counsel further submitted that the appellate authority also did not consider the said aspect, as would be very much apparent from a reading of paragraph number 22 of the order passed by the appellate authority. In addition to that, the learned counsel submitted that the imposition of punishment so imposed, the imposition of punishment of removal for service during the period in question, for even if for unauthorized absence during the period in question, was grossly disproportionate. He therefore submitted that the petitioner, that the impugn punishment so imposed by the removal order dated so and so, as well as the appellate order, are required to be interfered with. Mr. H. Kita, the learned senior counsel, appearing on behalf of the respondent number 2, 3, and 4, submitted that the petitioner was a habitual absentee. And this aspect would be apparent from the fact that there were earlier 2 departmental proceedings wherein the petitioner was already imposed punishment the learned senior counsel further submitted that the roster so prepared on 22nd of May 2020 and 30th of May 2020 by the Chief Judicial Magistrate, Florido, would show that the employees have been asked to attend the work, attend their office on a staggered roster. The learned senior counsel submitted that except the petitioner, all other employees could attend. And therefore, there was no justification for the petitioner not to attend. The learned senior counsel submitted that this being the 3rd case of gross misconduct, the imposition of the punishment of removal from service was justified. In addition to that, the learned counsel submitted, senior counsel submitted, that the scope of interference in respect to disciplinary proceedings is limited under Article 226 of the Constitution, inasmuch as unless a case of gross perversity is noticed or there is any violation to the principles of natural justice, interference under Article 226 of the Constitution is not, ought not to be made. The learned senior counsel also submitted that from a perusal of the records, and more particularly the records of the disciplinary proceedings which have been placed before this court, would also show that there is no perversity in the inquiry report. Additionally, the petitioner was afforded full opportunity, and therefore there was no violation to the principles of natural justice. During the course of the hearing, this court inquired with the learned senior counsel appearing on behalf of the respondent number 2, 3, and 4 as to whether the said charge sheet as well as the framing of charges number Roman 2 and Roman 3 by the inquiry officer did not tantamount to a preconceived mind for initiation of for imposing of a penalty before arriving at a finding as regards the gross misconduct. The learned senior counsel appearing on behalf of the respondent number 2, 3, and 4 referred to the judgment of the Supreme Court in the case of Yunus Ahmed. No printouts. You are doing well. The High Court has no money. We are grateful. Hey, come. Oh, what is this? So then, hey, you get whatever judgment you have. Tell me that. It is now Yunus Khan. Why you as Yunus, Mohammed Yunus Khan? Case of Mohammed Yunus Khan versus State of Uttar Pradesh and others, reported in 2010, 10 SCC 539, wherein the Supreme Court observed
Para 34 minutes. After discussing all the previous
that if the disciplinary authority wants to consider the past conduct of an employee in imposing a punishment, the delinquent is entitled to notice thereof. And generally, the charge sheet should contain such an article, or at least he should be informed of the same at the stage of show cause notice before imposing punishment. This court have heard the learned counsels appearing on behalf of the parties and have perused the materials and report. Before discussing the facts, this court finds it very pertinent to take note of. As to when a disciplinary proceedings can be, when and punishment which have been imposed can be interfered in exercise of the powers under Article 6 of the Constitution. It is the opinion of this court that the court can exercise the power that the High Court can exercise the powers under Article 2 to 6 in exercise for issuance of a writ of certiorari if the actions so complained against the imposition of the punishment is in violation to the fundamental rights of the fundamental rights enshrined in the Constitution. It is further pertinent to mention that Article 14 of the Constitution stipulates two aspects. One is equality before law and equal protection of law. Insofar as equal protection of law, if an action is held to be unreasonable, arbitrary, as well as irrational, it would amount to violation of the equal protection of law clause as enshrined in Article 14 of the Constitution. The several principles of law further stipulates that as to what would be reasonable in various judgments of the Supreme Court, it has been held that the principles as declared by the principles, that Wednesbury principles would be the touchstone to decide as to what would be reasonable. This court finds it very pertinent to take note of the judgment of the Supreme Court, of the observations of His Lordship's A. Pasayat, as His Lordship's then was. In the case of Rameshwar Prasad, Roman 6 versus Union of India, reported in 2006 to SCC 1. In the same judgment, His Lordships observed as to what would be the understanding of the principles of Wednesbury reasonableness. It was opined that the principles of Wednesbury reasonableness has three components as to be understood when an action of an authority is, number one, it is based on wholly irrelevant materials or wholly irrelevant consideration. Number two, it has ignored a very relevant material which it should have taken into consideration. Or number three, if it is so absurd that no sensible person would ever have reached it. In the backdrop of the above, let this court take note of, apply the same principles to the facts involved. As already stated in the previous segments of the instant judgment, this court had applied the act of the act of the act for which the disciplinary proceedings was initiated was at the time when the COVID-19 pandemic was in full rigor. There were various notifications issued by the government of India as well as the state government, thereby stopping the movement of the people in a manner unforeseen in these centuries. The charge which was made against the petitioner was that he had absented from 1/6/2020 to 6/7/2020. Unauthorized. And there was therefore a willful insubordination in as much as the petitioner in the earlier rounds, the earlier disciplinary proceedings, had given an undertaking that he would not repeat any such incident in future. Petitioner have categorically pleaded in his show cause reply, in his written statement, as well as also in the disciplinary departmental proceedings, that during the COVID pandemic, he went to the native village, which was 21 kilometers away from his office at Sipsagar town. It is the specific case of the petitioner that there was no availability of public transportation and he did not have any private vehicle to attend his office. Apart from that, there were various restrictions. A perusal of the entire inquiry report, as well as the order passed by the appellate authority, nowhere deals with this issue as to whether the petitioner was whether the petitioner would have traveled from his native village at which is 21 kilometers from Sipsagar town, or for that matter, the petitioner was not at his native village. Neither any evidence in that regard was tendered. Apart from about the evidence which have been tendered on behalf of the department, also do not show that any person, that any of these witnesses were residing at a distance beyond Sipsagar town. This non-consideration, in the opinion of this court, this non-consideration of the basic defense of the petitioner is a non-consideration of a relevant factor which would have otherwise changed the course of the proceedings. This court have also perused the materials which have been adduced as evidence. A perusal of this evidence would show that these persons have attended the office and the petitioner absented from 1/6/2020 to 6/7/2020. There is no denial by the petitioner in as regards his absence, he being absent during this period. Under such circumstances, the materials on the basis of which the inquiry report was made, as well as what have been observed by by the appellate authority, amounts to taking into considerations irrelevant factors and irrelevant considerations. An unwritten rule of law, constitutional and administrative, that whenever a decision-making function is entrusted to a subjective satisfaction of a statutory functionary, there is an implicit obligation to apply his mind to pertinent and proximate matters only, ensuring the irrelevant and the remote. This court also finds it pertinent, also finds it relevant at this stage to take note of. The third principle, the third aspect pertaining to when an action on the part of an authority can be said to be unreasonable is when no sensible person would have reached could have ever reached such conclusion. It is the opinion of this court that at the situation, at the junction at which the opinion of this court that no reasonable person sense a person who is completely insensitive could have even drawn up a disciplinary proceeding at a time for absentation, for being absent. For being absent at the time when the COVID pandemic was in full flow. There is no quarrel with the proposal. There is no quarrel with the facts to the effect that the COVID pandemic at that relevant point of time was in full flow. And in that regard, the various notifications issued by the government of India, the state government, and even the Gauhati High Court categorically mentions that it is only in extreme cases of urgency matters are to be taken up. More particularly, that the judiciary has been also impacted on account of the COVID pandemic. In this regard, this court finds it relevant to take note of the notification dated 4th of July 2020, issued by the Registrar General of the Gauhati High Court, wherein it has been categorically mentioned that even the court complexes have not been spared by the COVID-19 pandemic, inasmuch as COVID-19 infected persons have been traced from amongst the advocate fraternity, as also the judges serving in the district courts. Taking into account the above, it would therefore show that not only the initiation of the departmental proceedings was unreasonable against the petitioner, but the inquiry report, as well as the appellate court's order, were unreasonable, apart from being perverse in view of the fact that a vital aspect, the relevant factors have not been taken into consideration. Considering the above, this court is of the opinion that as the disciplinary, as the department, as well as the inquiry report dated 19/12/2023 is on the face of it, 1912 is on the face of it perverse and unreasonable. The actions so taken on the basis of the inquiry report of removal of the petition, the punishments so taken imposed upon the petitioner on the basis of the said inquiry report cannot be sustained in law. In addition to that, the appellate order of the appellate authority dated 19/7/2025 also smacks of arbitrariness and also suffers from perversity and unreasonableness and violates the mandate of Article 14 of the Constitution. First, this court further finds it relevant to take note of another aspect, which as to whether the charge sheet which was issued upon the petitioner was with a preconceived mind to impose penalty upon the petitioner. First, the learned senior counsel appearing on behalf of the respondents, though have referred to the judgment in the case of Muhammad Yunus Khan, and more particularly to paragraph number 34. But it is the opinion 34. But the said law so declared by the Supreme Court have been misplaced, in as much as the Supreme Court had categorically observed at the said paragraph, in the said paragraph, that before imposition of penalty, the past conduct of an employee is required to be mentioned, and the employee be put to notice. In the instant case, it would be seen that before ascertaining as to whether there is a case of misconduct, the past conduct of the petitioner was not only incorporated in the charge sheet, but charges were also framed, which in the opinion of this court shows that the disciplinary authority had done so with a preconceived notion of imposing penalty upon the petitioner. In that view of the matter, the instant petition stands disposed of with the following observations and directions. The impugned removal order dated 5/3/2024, issued by the Chief Judicial Magistrate Soraidal Hunari, is set aside and quashed. The impugned order of the Appellate Authority dated 19/7/2025 is set aside and quashed. Number 3. The petitioner be reinstated in service with full back wages the back wages be paid within a period of 3 months, 15 days. 15. 1 month he has the time to file appeal, so let him give 15 days. Then initiate. You file a contempt after 15 days. 15 days. Within 3 months from the date of the passing of the present judgment.
Reinstated on the date of filing of the certified copy. Reinstatement should be on the date of filing of the certified copy, so that he can join. Otherwise, it will another take time.
No. Why? You don't want to join.
I want to go.
So I'm passing the order, na? It's been reinstated. You go and join tomorrow.
Maybe
The day after you go join. After we get that order, once you get this order uploaded, then you go and join. You go and approach, he will allow you. This court, however, observes that the period from 1/6/2020, this court, however, observed that during this period from 1/6/2020 to 6/7/2020, as the petitioner was admittedly absent, the said period be treated as leave without pay.
Highly.
Another, how much, 17 or 15?
That's it anyway. This, that's I wanted to give.
Where is the other guy?
These are not for,
I think up there.
or I can keep it with the, but he was here. He was here in the.
I mean,
Board. My friend was come along, he will have.
okay.
One is 10 lakh and
Right,
one is
number.
4. Item 4.
After how much?
Out of total 46 and odd money.
You have already paid.
The first installment was already paid, the second one. The order did it 30th of April. That one. The para 16
You have already paid 20 lakhs.
plus 14 today, man.
14 is today, na?
14 today. By demand jobs.
Let me pass that. Give me a photocopy.
Very difficult to read, that is why I have given the original. The photocopies are even worse. One is for 10 lakh and the other one is for 4 lakh. These copies can be kept in the report, but very difficult to.
You can very well scan it, scan and heard Mr. B.D. Goswami, the learned counsel appearing on behalf of the applicant, who is the respondent number 5 in the accompanying writ petition, and Mr. R. Sinha, the learned counsel appearing on behalf of the petitioners in the accompanying writ petition. Pursuant to the order passed by this court on 30/4/2026, the instant application has been listed today. First, Mr. B.D. Goswami, the learned counsel appearing on behalf of the petitioner in pursuance to the directions passed by this court in the order dated 30/4/2026, more particularly at paragraph number 16, Roman 5A. 16, Roman 5, small a, Roman 5, small a. Have handed over 2 demand drafts drawn on ICICI Bank favoring the petitioner. Number 1. Bearing numbers of 500166 and 500167 of an amount of rupees 10 lakhs and rupees 4 lakhs respectively to Mr. R. Sinha, the learned counsel appearing on behalf of the petitioner. It is also seen that the remaining amount, that it is also seen that in pursuance to the handing over of the 2 demand drafts, an amount of rupees 12,32,835 remains outstanding, which the petitioner, in terms with clause paragraph 16, Roman 5B is to hand over on 28/5/2026.
Madam, in that respect, madam, may I renew my earlier payment some more time? Since we are bound to pay that, and we have been paying in time now. A little,
Mr. Sinha, I am also not there.
Yes, sir.
Let it be on, we have it on 9th of June.
yes, 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 I need. Before.
Mr. P.T. Goswami, the learned counsel appearing on behalf of the applicant submits that some additional time may be granted, taking into account that the petitioner applicant have duly discharged, have already paid an amount of rupees, how much?
34 lakhs.
34 lakhs out of the total outstanding of rupees,
6 million.
spending of rupees 46,32,835,
Yes.
comma, this court grants an extension for the applicant to make the payment by way of a demand draft on demand draft of the remaining amount of rupees 12,32,835. Demand draft drawn from a scheduled bank drawn in favor of the petitioner number one of an amount of 12,32,835 on 9/6/2026. Copies of the demand drafts so handed over to Mr. R. Sinha are kept on record. And marked with the letter Y and Z. List the matter again on 9/6/2026 at 2 p.m. The interim order which was passed on 34/2026 then extended to the next day.
Much more.
Deeply obliged, Your Lordship.
Wonderful. Mr. Sinha, it is because of Mr. Goswami you are getting the payment.
No, because the Lordship has taken up the matter and expired it in such a fashion that they are bound to pay, Your Lordship.
Not me. On me, I do for everybody. It is because of Mr. Goswami.
I'm deeply obliged, Your Lordship. Your Lordship, the last draft has been handed over to the petitioner and he has acted.
It's okay. It has been, you informed us, but these are demand drafts, don't worry. What is this item?
Is to see the date of promotional. The matter, your lordship, my lord, are at length, my lord, matter relating to the, my lord, interest part on the now.
Oh, yeah.
My lord, a detailed order has been passed on 23 of February.
They asked them to do something. And they before this paper will, the thing is kept on record and marked the letter X. Till they contracted. Became of 7/5. Started to read. They will file
Right, madam, and that is on record also.
29/4/2026.
Running page, my lord, 90. Paragraph 3.
So you have got the other amount
What the other amount?
when?
My lord, on my lord, 8/5/2015. 8th of May 2015.
So it is only the question of interest. What do you have to say?
Lordship,
It's an acquisition matter. You've done the acquisition in terms of the Assam land, the Acquisition and Acquisition Act. And there the principles apply out there as regards the interest which is parameter at that point in time to section
34.
34 of the Land Acquisition Act. That is 9% for the first year and 15% after the first year.
Lordship, section 34, Lordship. The Deputy Commissioner.
Not Deputy Commissioner. The question is you have taken over the possession. Take some award or whatever it may be. After you take over the possession, the interest runs at the rate of 9% for the first year. So from 27/5/2001 to 26/5/2002, it is 9%. Yeah, from 2002 onwards, you have to pay interest.
Lordship,
There are two options. I can ask him to go there, whereby you will have a much bigger problem. Bigger problem lies here. You are to pay first the principal, interest, cost, and interest. Apportionment is done first towards the interest, then towards the cost, then towards the principal. Okay? This is a judgment of the Constitution Bench in the case of,
I have forgot. my
in
lord.
the case of, then why should I? Good, sir. So therefore, when you are doing the competition out there, if you have paid the amount in 2015, first it will go towards the interest, meaning thereby the principal is still alive. What is the amount of compensation paid to you?
56 lakhs.
26 lakhs.
26 lakhs.
Okay, 26 lakhs.
19,001.
19,100 rupees.
Then how did you pay? Where is the computation? Any idea? Where is the computation? Now these 26 lakhs, 19,000, whatever you have paid, first it has to be, you have to calculate from the date of handing over possession at 9% for first year, then 15% from next year onwards. Okay, so in the year 2015, when you pay, if the amount which you have paid is more than what the interest has accrued, then obviously some principal can be touched. But on the very principle, there will be continuously interest accruing. So this will have a very disastrous consequences upon you. So better, both of you settle it out. Come to a figure of another 22 lakhs and give it to him and finish it off. One. Or if you want, this court can very well look into it. And after looking into it, you may have to pay a cost. The way you feel. BTC is a very, very rich six-schedule district.
This acquisition has been done in 2000. In that period, BTC was not even formed. This acquisition, land acquisition has been done in the year 2001. And possession also has been taken in 2001. And in that period, BTC was not formed.
Understood very well. Petition has not been formed. But the question is, whoever has taken it, you catch hold of them by the neck.
Then Lordship, the matter will be sent to mediation for settlement if possible. Other party agree.
Mediation, nothing else. It is to the, they want to go do it, nothing else. It is the rate of 15% is. But exactly, very well. I can send it to Nitish, no problem. Go there. But the problem lies there. Ask him to come to a settlement and finish it off.
Then he may approach the authority for adding a representation for settlement, then if settlement comes into then Lordship.
But your officers do not understand the importance of the issue. They say, okay, I'm there, tomorrow I'm not there, I will go away. And we won't pay. BTC at the end will pay. I'm only thinking about the BTC. Come up with some figure of amount which is equal to the amount you have paid. And then we can ask him to finish it off. That's the only suggestion I can give. Otherwise, I also know how to tackle the petition.
Yes, sir.
Nothing. But if I allow this, by going to the merit, you are in bigger trouble. Ask your senior standing now. Ready.
Not in the court, Lordship.
Not in the court. Court is not in the court, then what happens?
Then Lordship,
Is how the petition is running.
no Lordship, in other court, in the other court.
Ask him to appear. We're having it on next Tuesday. Need to get that issue. Is the matter again on?
No, Senior Counsel Manish Goswami is appearing online in this matter. I'm assisting him. Mr. Goswami is appearing online, my lords. I'm assisting him physically.
What is the matter about?
I believe he's not audible, my lords. There is a writ petition and an impleadment application listed. Mr. Goswami will lead me, my lords.
Yes, I can't hear anybody who is appearing video conferencing. I can hear you. You argue. No, you argue.
I'm happy to argue, but I will need instructions.
Don't want to argue, then we adjourn the matter, final that. Then in interim order. No,
We
then
have
we
filed an
adjourn it, final that.
We have filed an application for impleadment in this case. Maybe the civil suit which is pending. My lords, we have strong objections to the impleadment application, my lords. It is my submission that the moment we allow them to be impleaded, this writ proceeding is going to turn into a civil forum, which cannot be your mandate of, it will become a civil forum, my lords. This argument is, I will just,
Hello,
I think
what is your case?
he's audible.
What is the case you are filing?
The writ petition, my lords, is basically directed, Mr. Goswami, you can speak. Yeah, he's audible now.
The audible? Tell me, Mr. Chaudhary, tell me, is he audible?
Mr. Goswami, you have to be audible. You're not audible.
And hell, hear you. Very difficult. They have to also get judicial training on lip reading.
My lords, I have been a contractor with,
What is your case? Tell me.
my case is that ONGC has changed my vendor code, my contractual status under the current contract by entertaining requests by third parties who have absolutely no privity of contract between me and ONGC, as a result of which I am not receiving any payments. They want to seek impleadment now, and I have strong objection to that impleadment application. Yes, my lord.
Cannot be able to direct the effort to restore the petitioner account number with the state bank, PAN card. Oh, so you have now become a partnership.
I had become a partnership, but the partnership did not become a vendor with ONGC. I was a proprietor originally, and in the capacity of a proprietorship, I had contracted with ONGC. My vendor code pertained to me as a proprietor. I became an
And
old man. My son died.
I'm
As a
sorry, but if I'm audible now, Lordships.
Yes, you are audible now.
I'm very sorry, Lordships. Extremely
Yes.
sorry for the inconvenience caused.
You see, Supreme Court has not closed.
Pardon, Lordships?
The Supreme Court has not closed down.
yet,
Supreme
my
Court
lords.
has not closed down. I appreciate, Lordship. My personal apologies. I couldn't come down, Lordships.
Okay. Okay, now tell me.
Yes, Lordships. Now, this is basically initially we had filed a writ petition seeking certain reliefs against ONGC. Now, if Lordships will see the prayer that we seek, please come to page 30 of my writ petition. Kindly say, because now what has happened is that Mr. Das's client has filed an application for impleadment. So today what Lordship has to first decide is whether this impleadment application needs to be allowed or rejected. So today they have filed an application, we have responded
They
to
have
it.
filed the application today. They have filed the
No,
application today.
today Lordships will have to decide that issue. They have filed an application, we have responded to it also.
Okay, my question is, what is your case? Then I will know why he wants to become a impeded.
Yes, so therefore,
Yes.
please kindly have a look at the prayer. What is the prayer we are seeking?
Yes.
At page 30. Issue a mandamus. A mandamus shall not be issued to direct the respondent number 1 to restore the petitioner's accounts so and so with State Bank of India, ONGC Colony branch, PAN card number being so and so, and GS-19 linked to his vendor code. The second prayer is, certiorari shall not be issued to quash the decision of the respondent number 1 to unilaterally alter the status of the petitioner under the contract agreement to a partnership. And number 3, mandamus shall not be issued to direct the respondent number 1 from refraining to act or communicate with any third party except those expressly authorized by the petitioner herein. Now, we have filed a written submission. Would Lordships kindly take it up? Because that encompasses the whole case. We have filed a separate volume. If Lordship will kindly take it up, it will be very convenient for the court. If Lordships
you
have that,
entered into an agreement with ONGC
yes, the privity
on the
of
basis
contract
of
with,
as a proprietorship firm.
I'm so grateful, Lordships.
Now you having entered out there, now what has happened? You have become partnership.
I'll tell Lordship what has happened. We had the privity of contract is between ONGC and the proprietorial firm Rohini Gogoi. During the subsistence of that contract, it is a fact that I entered into a partnership with Mr. Das's client. And we made a partnership firm. But that did not dissolve the proprietorship firm. It existed independently.
If it was the other way around, it would have been different.
Yes, Lordships. This is
It would have been different if it was a partnership firm getting it dissolved and becoming proprietor, then the question would have been different. But otherwise, the proprietorship firm, which is actually a single person,
yes, Lordships.
that entity remains irrespective of that person entering into a partnership with anybody.
Yes, Lordships.
That's your case.
Correct. Right, my lords.
Then why do you need a written argument?
No, written argument, no. What is our case? So therefore, today they have filed an application for impleadment saying that we as a partnership firm are a necessary party to the list.
Obviously.
Now, in the context of the prayers,
Obviously, Mr. Nami, if an action has been taken by the respondents, which you are alleging to be bad, on the basis of what the Mr. Das's client have alleged, he may not have a right to have any interference with the agreement. I'm not saying that here, the partnership, you may have a good case on merits, but it is at his instance, the respondent have taken action. Isn't it? It is
Yes,
at
but
his instance, the action has been taken.
that they do not admit. That they do not
No,
admit.
Mr. Gustam, they may be wrong. For that, wait for some time for deciding the main matter.
Very well, then
But the fact that they have a right, because at the, you are asking a direction that they should not hear the respondent. They should not take into consideration any third party interference. That's your case. That
no,
is your
no.
third prayer. Yes.
That is my third prayer.
So therefore, if you give up that prayer, no problem. You want to give up that prayer?
If my first prayer and second prayer is allowed, I am satisfied, because ultimately what Lordship will kindly appreciate.
Then also they can very well take into consideration anybody third party's request. You have no problem with that.
Pardon, Lordship.
You have no problem with the third prayer being given up. We strike out the third prayer, then Mr. Das would have nothing to say. Okay.
We are
This is no problem. Then we first go into 1 and 2. Third prayer struck off. Mr. Das is no problem. His application will be struck off. Now, therefore, we will consider as to whether a partnership firm can do it or not. Over. That is simple. Let's pass down. Strike out 3.
May I
And if you won the third prayer, Mr. Das comes in. Then let Mr. Das also come in and let us adjudicate 1 and 2 along with 3. I understand your case. Your case is not a very complicated case.
Very
You
simple
enter
case.
into an agreement as a proprietor or as an entity which is there. Is an entity or a proprietorship firm is actually a trade name of a single person. So you enter into an agreement. The fact that you have entered into a partnership with somebody does not change the character of the agreement between you or the ONGC of a proprietorship firm. That's your case.
So therefore, the challenge is to the arbitrary action of ONGC.
Absolutely. Let us
I think-
hear. We do one thing. We make him a party, and thereupon 30th of May, Supreme Court is closing. Then we get you out here. And here you go. And finish it off. It's a 2-minute job. But the
Lordships may,
problem is, if I plead him, I have to give him a chance to file his reply.
Lordships may do one thing. It is only my request.
Yeah.
Lordships may today not allow the implement application. Let everything
I'll
be
allow
heard.
his unless you give up 3.
No, Lordships, I will have to take
And
instructions.
later on, you give up 3. Later on, if ONGC comes up and says that these are the things on which, and this court finds out that it is very difficult to adjudicate without him. Now, if he becomes a necessary party, then obviously we have to dismiss your writ petition with prejudice. That's the very fundamental of a.
Yes, because today, if
So let
what
us
we-
make him a party. Better off. We
not
have a
today,
good case,
Lordships.
but we have to make him a party.
Not today, Lordships. My
No,
request is
just
only,
now, in 2 minutes.
Lordships, my only request is let all the applications and the writ petition, let the writ petition along with his application be heard comprehensively,
We'll hear
Lordship.
the other matter when it is, we make him a party now, and after getting him a party, then we pass order, we'll finish it, ask him to file his reply, you file your reply, then we'll finish up the matter in the month of June before you go back to the Supreme Court.
Can Lordships for the time being pass it over? Let me at least take instructions. I'm all alone sitting here. I have to take instructions of the client. I can't immediately. If Lordships can just give me 10 minutes time.
Mr. Goswami, if you want to take an instruction, let me ask Mr. Chaudhary out here. He is the person who is your
Yes, he
instructing
will take
counsel. So
instructions. He
then
will
let
take
me
instructions.
directly put it to him. Yes.
Let him at least give you 10 minutes time, Lordships. 10 minutes.
I may be allowed these 10 minutes, but before I may be allowed, can I just make one submission, my lords, in
Don't-
addition to what Mr. Goswami has stated?
So therefore, either one of you has to speak. This is Gauhati, not Delhi.
Then
No,
Madam, you
even
pass the
Delhi,
one,
we
lords.
it's very strict.
Delhi, many councils speaks together, not here.
No, I
Okay, 10
appreciate
minutes
it.
time, I'll allow you to consult with your.
Give us 10 minutes time, Lordship.
10 minutes now.
Well, grateful, Lordship.
Yes, Mr. Chaudhary. Your matter. Kaziranga, blacklisting.
My lord, ultimately they have filed the affidavit today. We may be allowed some reasonable time to file a reply. In fact, I haven't even had the time to go through.
They said that they had filed it yesterday.
So yesterday, we were supposed to file in positive time and there was, in rush, we forgot to given the one of details, the phone number allowed. So we couldn't file it.
We keep these then. Don't spoil it with me now. It has been submitted that the forest department at last had filed the affidavit in opposition. Mr. I. Chaudhary, the learned senior counsel, assisted by Mr. Sohida, submitted that the petition, the petitioner would like to go through the same and if necessary, file a reply. How much time?
But the client is from Hyderabad. Your lordship will allow at least 2 weeks.
We'll have it after vacation.
Yes. There, we have a protection.
Taking into account the above, list this matter again on 28th of July, 27th of July, 2026. In the meantime, the reply be filed on or before 22nd of July, 2026.
Right.
The registry shall bring on record the affidavit filed by the forest. Yes, Bata India.
Yes, my lord.
The thing,
Yes, we are agreeing to that
how much
proposal.
it was?
6 lakhs. my lord.
Ready? Both of you file a petition. When? Before vacation?
For vacation. my lord. Yes.
Before vacation, file an joint affidavit that you will settle with 6 lakhs. And you will plead with 6 lakhs a matter. Okay. It has been submitted at the bar by both the councils appearing on behalf of the parties that the parties have agreed for a one-time settlement of the claims of the respondent at rupees 6 lakhs. It is the opinion of this court that the said aspect be brought by filing an affidavit, either a joint affidavit or individual affidavits. List this matter again on 9th of June. Can you file it? 9th or 16th?
Let's let it be on 16th.
On 16th of June at 2 p.m. for final disposal.
In the meantime, they can bring the check also. You can receive and
You bring the check, it is,
My lord,
we
only
can
thing is
close
that
it.
He has to follow some, the respondent has to follow some procedure, my lord. That he will follow. I'll ask.
What procedure?
board direction is there.
No, my lord. That, his
Don't
account
worry,
number and all.
Mr. Counsel. The moment he says that, you see, he has an award in his favor.
Yes.
Okay, I will close the award. Once I close the award, man, nothing remains. You have approached this court, why? You have approached, you are aggrieved by the award passed, whereby there is a direction for reinstatement with payment of back wages. Matter has been amicably settled at 6 lakhs. When I pass that order, I will very well say that he loses all his claims upon receipt of the said amount. Once that is given, what else there is?
No, my lord. To make the payment, to give him the check, that his PAN card, cancel check, something may be required, my lord.
You are going to make it transferred by ear.
Yes, my lord. By way of check, I have to. The company will transfer it by way of check only.
So if you are paying with a check, get the check.
If required, he will cooperate, my lord. I don't know, my lord.
In the meantime, you have a talk.
Yes.
You can do whatever. If your check is there, then you ignore the bill. But we have to pass an order. We have to pass an order that it had, in view of this settlement, nothing further remains in the award.
Yes.
Because that order I have to pass. Without passing that order, otherwise that award will be impending upon.
Yes. Okay. Oblige. Consider.
Good. Mr. A to D, Dr. A to D, what is your case?
Lordship
Clearly
regarding,
covered by a judgment of Udain IVP.
yes, Lordship, you should cover.
So there was a decision is there, the central government, then it should be reconsidered. But here in this case, it is not there. You have a now, I have received an absolution.
We filed your affidavit. But why affidavit has not been filed? This is an old matter. This is a 2019 matter.
I have received the indication from the authorities. It says that on 2020 itself also that we did customers must be forward, but they have not filed. Okay, follow the time it is.
Capital subsidy of 2007 or 2009, 17 or 2097? Which one? Dr. Todi?
Lordship, 2007. They have 2007. My application was filed in 2018, which was rejected. On similar facts, this honorable court has passed order
Earlier, was.
and
to
to reconsider.
The instruction was forwarded.
the three judgments by orders passed by this honorable court on a similar facts. One is WPC 5497. Lordship may turn to page 18, the second paragraph, second, third, and fourth paragraph.
This is a consent order.
Because then the second order and the third order same line, it was disposed of.
Yeah, because saying they are out saying that they are actually bad. Right.
But consent was the only one that first.
If I hold it, the action is bad, then obviously I will send. But nearly on the basis of some lawyer comes up and says that, okay, we will again reconsider. That doesn't make it proper for this court to exercise. Then if they are doing it out there. Necessary will pass. What does Udon say?
Same lordship, reconsider lordship.
See what has been faced by the lower court. Since the repetition are also similarly having similar grievance on the instructions obtained from Iran, means that the cases of the repetition will also be considered appropriately by SLC in the next week. If that be so, it would not be necessary to enter into the adjudication of the issues involved. With the consent of the learned counsel, I therefore this type of orders I do.
But based on this thing, lordship, the SLC has reconsidered.
But that's go there, file your representation there. File your representation.
They filed it, it was rejected, then we came up with.
Therefore, whether the rejection is right or wrong, then, and Mr. Gugoi, are you going to give any consent? He doesn't give a consent, how will I apply? You cannot apply a consent order to a petition. Consent is different. There's no res judicata in consent. Is there? Okay, Mr. B. A. Gugoi. Learned Philippines Civil Government Advocate submits that he had received the para-wise comments and will be filing the affidavit within 2 weeks. List this matter again on 17th of June 2026. In the meantime, the affidavit be filed on or before by the state respondents. Have you made the union a party?
Yes, yes.
The respondents on or before. 3rd of June 2026, reply be filed by the petitioner. If a reply, if any, be filed by the petitioner on or before 15th of June 2026. Yes, what do you think?
Hello, it's my senior will meet me.
The instruct. The new instructor.
Easier, my lords.
Yes, Lordships, thank you for the 10 minutes grace, Lordships. Sometimes the best ideas come for such breaks. Be that as it may, Lordships, uh, we have taken instructions. Lordships may pass orders, but Lordship will kindly appreciate one thing, just one submission. The remit of this writ petition is only to test the arbitrary action of the ONGC, who are changing my,
Whose instance it has happened?
pardon, Lordships?
At whose instance it has happened?
It is our allegation that our email was misused by the people who intends to impede themselves.
But therefore, it is at their instance it has happened. So therefore, let us hear them also. And then pass an order. Don't
No,
you
but-
think your judgment will be more concrete
No, what
than
we are
to
trying to
become
say is that
than to have an order without them? And
No,
then
we-
they were
we-
saying that we have never made a party and the court also didn't make us a party. So therefore, any order passed by the High Court would have no implication. Let us again trouble Mr. Manish good service.
my concern is only this. My
Or
concern
if
is
you want to come again by filing another petition, then you very
no. My concern is only this today.
that would be multiplicity of proceedings.
No,
So
no.
all
ma-
the prerequisites for becoming a party, is there.
No, my
Okay.
concern is only this, Lordships.
No
My
problem.
concern
We
I
make
need
them
to
a
express
party.
to the court.
We will hear them.
No,
Mr.
my
Viswanath.
concern is only, please listen to me for 1 minute. Just 1 minute, Lordship.
You have very kind judges in the division bench. They listen more.
No, just one minute, Lordship.
Mr.
My
You
concern
want
is
your
only this, that
submission,
it should
you
not be
have-
turned into a disputed questions of fact, and the writ court says there are disputed questions of fact. Now
It
we
is not
cannot
a
enter
question,
it.
what they are going to argue, we'll look into it. But the fact remains one thing. You had an agreement, your case is you had an agreement with ONGC
Yes, Lordships.
as a proprietary firm.
Lordships, and that exists, that subsists.
Now, whether the ONGC can convert it into partnership for the fact that you have entered into a partnership with Mr. Das client, that's the issue. It'll take 2 minutes in your favor. But let us hear him. Okay.
Very well.
Mr. Das, what do you have to say? Otherwise, you could look bad. Be hearing them for allowing your one thing by a suit has been filed for the same subject matter.
If Mr. Das can speak closer to the microphone, I can't hear what he's saying.
My lord, a suit has been filed. The detail they have not got, only they have mentioned a suit has been filed. Prior to filing of this writ petition before this, before the broker court. We filed. We filed, they were the party, defendant, and written same exact. Please see the suit. My
No,
lord, this
they have
subject matter,
filed,
kindly
therefore,
see the
all
title
these
sheet
facts, they have already
77.
filed a suit.
see 77, my lord.
So they have
See
filed
page
a suit.
77. 77. Making ONC also, we made ONC's party. And kindly see the prayer. See the prayer, my lord, at page 99 of the suit. See the second prayer, my lord. Number 3, my lord. My lord, kindly see the pleading at page 84, my lord. Changing from ICC Bank to State Bank of, kindly see 84. Page 84, which starts from paragraph 83, my lord.
But tell me,
Yes.
who had entered into an agreement with ONG?
Rohini Gogoi initially entered into an agreement. The contract was awarded to him, there was an agreement. Now that's a fact. Now, what is our case that they were in financial hardship. So they approached us and it was not in good health. So we entered into an agreement. And whatever whatever the amount, what was the pending, that we paid, certain 91 lakhs has been paid. Now, investment, we have made an investment. Now, there is also an agreement, if your lordship kindly see, the agreement is at page 16, my lord, please see page 16. Partnership, kindly see, my lord. Yes. Please see page 18, my lord. Please see 18 last, and whereas the party hereto of the first part due to his ill health issue, it is not possible him to present every time for observing official formality, and therefore for active management need and for purpose, accruing capital for
Show
the
me the agreement between you and ONG.
Yes, my lords,
You-
while,
O-
sorry,
That's all. Where is the
page
agreement
39,
between-
page
Where
39.
is the agreement between ONGC and the firm?
Please see page 39.
Page 36, it starts
39,
of the writ petition.
please see 36.
No, no, no.
And
Maybe-
this is which is
Whatever may
informed.
be, Mr. Das, whatever may be, we can make you a party, that's a different story. But you see, there has to be innovation of a contract. Not the innovation of a contract that you
I am
have
so
entered
very
into.
grateful.
Please, but this is the problem.
Don't worry, we make him a party, then we hear again. Why should I say it?
I'm so very grateful, Lordships.
We make him a party. It's a different thing. He may have a good right to challenge it in a suit, it's whatever maybe get to whatever amount he's entitled, but this is between you and him. It is between Manish Goswami's client and Mr. Digantoda's client. That is there. But ONGC can't be involved unless there is an innovation of a contract, section 6. That's the basic.
And clause 32. Very clear, Lordships, of the contract.
You see, my question is normally a partnership, proprietorship is understandable. But can you change from proprietorship to partnership? My question is that there's a very big difference. We will see when we hear Mr. Manish Goswami physically out here, not in this.
It is always a pleasure, Lordships. Always a pleasure. Lordship will keep it parted, Lordships.
Mr. Manish Goswami, let me see, counsel, already appears on behalf of the.
This is an application filed by the applicant. By the applicants. Seeking leave of the spot to be arrayed as respondents to the accompanying petition. This court have duly taken note of the cause of action for which the petition has been filed, as well as the relief which have been sought for by the petitioner. It is also seen that the change of the bank account number which has been
GST,
challenged by the petitioner
Vendor code.
is on
vendor
account
code.
of the intervention of the applicants. Considering the above, it is the opinion of this court that in addition to that, the petitioner have also sought for a relief that the ONGC should proceed with the terms and conditions of the agreement entered into by and between the petitioner along with the ONGC without the interference of the third party that third parties, that is the applicants herein. Considering the above, it is therefore the opinion of this court that the applicants herein are necessary parties to the accompanying petition. Accordingly, this court therefore treats the applicant number 1 and 2 as the respondent number 3 and 4.
3 and 4.
To the accompanying with petition. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court. And the registry shall make necessary changes in the course title and as well as update the same in the CIS. The interlocutory application accordingly stands disposed of. Mr. Didas, the learned senior counsel assisted by Mr. Arsha, appears on behalf of the newly implemented respondent number 3 and 4. The learned senior counsel submits that the respondent number 3 and 4 are in possession of the pleadings in the instant proceedings. And as such, there would be no requirement of any service of any extra pleadings. The learned senior counsel therefore submits that the respondent number 3 and 4 would like to file their affidavit in petition. Mr. M. Busami, the learned senior counsel appearing on behalf of the petitioner submits that come up for the first time.
No, Milans. It has come up a few times.
The same order that the impugned actions on the part of the respondents is affecting the petitioner. And therefore submits that the matter requires an early disposal, more so when there has been no interim orders passed.
Considering the above, this court fixes the matter on 16th of June 2026 at 2 p.m. for final disposal. The respondent number 3 and 4 shall file their affidavit in opposition on or before 1st of June 2026. Liberty given to the petitioner to file reply thereagainst on or before 12th of June 2026.
Obliged, my lords.
Lordship is keeping the matter partner.
What?
Is it being kept? No, just I wanted to know. No.
If I am taking a bench or it will come in. Yes, we can miss the matter for further hearing.
Grateful,
Further
Lordship.
hearing on 16th of June 2026 at 2 p.m. Final disposal.
Grateful. Good.
I hope, Mr. Goswami, you are there on next week.
Yes, certainly, Lordships. I will be there because I have strictly followed what the Prime Minister has said, no foreign trips. He has appealed to the whole country. Very good.
We should have better video conferencing links then.
Very good. Grateful, Lordship. Grateful.
Yes. What is this?
Yes. It's a matter which your lordship has taken up earlier. Like to withdraw this case, we have taken liberty to refile.
I think better.
Otherwise, there will be a clash of interest, number one. Order 23, I have seen by, if there are more than one plaintiffs, then my lord, it will be difficult. Whether I am appearing, I don't know, again, there will be a clash of interest.
Because what happens? Comes out.
Yes, that too.
Then there is a big problem with them.
No, I have seen.
And he has done to me because he has to say, he has to give a good reason.
No, there might not be, the entire situation changes after they file an affidavit. We were not aware of it. Thereafter, we came to know that there is an anomaly in the selection. There has to be recasting. Recasting cannot be done. Recasting only can be done with my humble submission. We have to withdraw, file a fresh petition before this court. If 3 is willing, they will. And number 2, I don't know who will appear in this case. My lord. Of course, now situation has become different by now. I was not aware of it. When they file affidavit, then only I came to know the situation.
After the affidavit, fact, this could have been done immediately after the affidavit. Even then, Miller, the senior counsel is now.
In fact, it could have been finished now.
That's true.
He
Senior-
said, let me consult the senior.
Correct, Miller. Correct.
It's the deed after then it's the council. Submits that taking into account the stand which have been taken by the respondents. The petitioners would then have to. Petitioner cannot proceed in the instant petition in the manner in which the petition has been filed, as there apparently appears to be formal defects. He therefore submits that that the petitioner be permitted to withdraw the petition with liberty to refile. Taking into account the above, this court therefore closes the instant petition on withdrawal. Liberty is given to the petitioners to be filed. It's advice. It will. I think, sir.
I is then, I'll also.
I will not pass that on.
It's fine, repeat. Very good.
These are lawsuits.
This is a,
Yes, Mr. Na.
my lord, this is a matter where the Educational Deputy Commissioner Dorong has given me a notice to deposit annual revenue of 58 lakhs, whereas possession was not handed over to us for the fishery money. The impin order is page number 41. In lordship's order, my lord, earlier, that's dated 29/10/25.
What do they say in the affidavit?
My lord, they do the possession. Yes. He has filed the affidavit
Let them, they'll submit or I'll submit my lord. Yes, they please. Shall I submit? Let me place that now.
Now, your case is that you have been granted the settlement. So the settlement has been
Yes.
granted to you, you have paid the security deposit as well as the first
Yes,
case
yes.
money. And now they are asking for making a further demand without handing over the.
Yes, yes. Now, what affidavit they have filed? In the affidavit, they have given what order by which the Mangalore Revenue Circle Officer, page number 51 of their affidavit, my lord. There, the said officer, he has written that on 4/6/24, he has given us the position, my lord. 14, that's a, yes, 17, yes. Page 51, annexure A. 14/6. Annexure A.
Written out there.
14/6, yes. Kindly see the next page, my lord. It is the same officer, Mangoldoi. Your lordship will find, subsequently he wrote to the deputy commissioner and circle officers, please come, we want to hand over the thing. That's in page number 31. But after that, please come to page number 53, my lord. It's Bharnikula. Just kindly see one thing. Okay? Bharnikula, page number 53. 52 is in English, 53. First paragraph, last line. Dorong, Fishery, image, Sotira, limited on Sima Sonjai Dia Hall. It is the whose signature is nothing, my lord. No, it is Sima Sonjai Dia Hall. That is boundary. Nothing has been mentioned in the English part of there also, lordship, but can we see? And this fishery is spread out to 3 revenue circles. 3 revenue circles, not one. Shipaja revenue circle, Pub Mongoldo revenue circle, and Mongoldo revenue circle. Now kindly see the next, my lord. Next one, this is given by Tolgao revenue circle. He said, page number 51. It doesn't fall under Tolgao. That is okay, no matter. Kindly see the other one, my lord, now. Page 55. Kindly see page 50. That is by Pub Mongoldo revenue circle. What he says? It was handed over, but it was cancelled. Page 55. 29/7/25. Although the possession certificate after giving possession of the one such and such was provided to Ananta Das secretary, but due to dispute over the fishery, said possession cancelled. This was said by Pu Mongoldoi. And now kindly see the next one. Page number 57.
Your name is?
My son, yes.
You are possessing since 15/3/2024.
That is not correct. I'll show to your lordship, my lord. In fact.
Members of Sati Radhika have been fishing in number 1 Dorong.
Yes. Kindly come to page 57, my. Page number 57. Sipajar revenue circle. Because of my fishery faults there also. Here he says it was not handed over to the petitioner. That means circle officer Mongoldo says it was handed over. Where is the same officer in page number 39 in the petition? Lordship kindly subsequently wrote to the other members, please come, we want to hand over the fishery. If it was handed over, how can it be my lord?
Where?
Page 39 of my petition, please come. Page 39. 17/12/25, he wrote to the additional deputy commissioner. It was handed over on 14/6/24, page 51. Now please come to page number, my lord, page number 39. Page number 39. That is on 18/2/25 by additional deputy commissioner. He writes to Mongoldoi, to circle officer Mongoldoi, Mongoldoi, Dolgao, Sipaja revenue circle, asking them, inviting a reference to the government letter on such and such. You were direct to hand over position of Dorang Bongto Satira Dika. My lordship has seen this one. Circle officer Mongoldo revenue circle appointed nodal officer. Kindly come to the next page.
All these come under where? Under whom? Which district?
Yes, Dorang. Sporting Dorang.
As per these reputed by the because handed over.
He has filed a
Additional deputy commissioner file.
Anurag Kupanes, yes. Additional deputy commissioner, page number 47.
This affidavit has been filed by him.
Yes. But the same officer has written to the circle officer in 25 that handover but the same officer giving the notice, knowing fully well it was not handled.
Fishery department? What do you think?
I think our position, DC is the competent. So. Lordship,
Money goes to whom?
money goes to government account. DC deposit to the government account. DC does not.
Fishery. To the fishery department.
No, not to the department, Lordship.
Will go to the fishery department.
Maybe at that
It is
time.
under your head the money go. By the DC deposit is in your head. But therefore, you are to look into it as to whether it has been done or not. Who has issued that notice?
My lord,
Even
additional deputy commissioner, impugn order notice he has given, this notice, page number 41.
better off, I think, you make a inquiry and submit a report.
Not. That has to be
This is under the fishery. Na?
fishery department, yes.
So let the commissioner and secretary make a inquiry
Hmm.
and give a report as to whether there has been handing over of the entire fishery, because there are conflicting reports
Lordship.
from various circles. Because if I remember, this particular fishery comes under 2, 3 revenue circles.
Yes, Lordship, yes. Lordship.
Some revenue circle officers says that it has been handed over on 14/6/2022.
Lordship.
And in some circle officers, Sipadar says something else. So at the end of the day, it is you who is losing out on account of that.
Yes.
Yes, so I think it is better for you.
Right.
I took up this matter earlier, I remember.
Yes, yes, lordship, my lord, lordship took up this matter, then dispose of directing the authorities to settle, my lord, as per law, and they have settled with this petitioner, my lord.
Huh?
Earlier, this matter came to your lordship, after a lot of fights earlier. The
They
lordship directed the authorities to.
are enjoying daily basis
Yes.
earlier.
No, they subsequently lordship directed them to settle, my lord, as per law, and my lord, it was
Earlier.
settled with this particular case. Lot of litigations are there.
This was heard Mr. M. Nath, the learned senior counsel, assisted by Mr. P.P. Bora. The P. Sharma, the learned standing counsel of the fishery department, and Mr. M. K. the learned counsel appearing on the district administration. Gaurav. The issue involved in the instant proceeding relates to a challenge to a communication dated, notice dated 25/9/2025, bearing ECF number 52763/748, issued by the Additional District Commissioner, Fishery, Dorong Mongoldoi, whereby the petitioner have been asked to make certain payment. In spite of the fact it is the case of the petitioner that the petitioner till date have not been handed over the fishery in question. This court has duly taken note of the affidavit so filed by the respondent number by the Additional District Commissioner, Gaurav. And from the affidavit, it appears that there are conflicting reports amongst the various circle officers. It is therefore the opinion of this court that a report from the Commissioner and Secretary to the Government of Assam Fishery Department,
Additional chief secretary.
Additional Chief Secretary to the Government of Assam Fishery Department may would be relevant for ascertaining as to whether the petitioner had been handed over the fishery in question, the possession of the fishery in question, and if so, when. List this matter again on 21st of July. 21st or 22nd. This is a matter, not a long matter. On 22nd of July 2026. In the meantime, the Additional Chief Secretary Fishery, Government of Assam Fishery Department shall direct it to cause an inquiry as regards handing over the possession of number 1 Dorong Brahmaputra Fishery to the petitioner and submit an affidavit to an affidavit filed by a competent officer of the Fishery Department of the Government of Assam. The said affidavit be filed on or before 17th of July 2026.
Highly appreciate.
Same order after it shall continue. till the
Highly appreciate.
That's what I think.
affidavit filed, not filed.
No, I will keep that.
Let me, last time you did not appear, this time affidavit not filed. No affidavit has been filed by the Gauhati High Court. In spite of an assurance given on 2/4/2026 that the affidavit would be filed on or before 4/5/2026. For the ends of justice, this court grants an additional time to the Gauhati High Court to file the affidavit. First, list the matter again on 18th of June 2026. A final opportunity is granted to the Gauhati. A further opportunity is granted to the Gauhati High Court to file the affidavit on or before 15th of June 2026. Where is your other side? We lead.
Matter is anything to the award first by the labor code. My lord, here, my lord, if we go by the award, my lord, to my sufficient, my lord, there is no sufficient reason was given. If you go after discussing all the submissions,
Similar,
the
this is the same officer, madam, same officer.
labor code. Yes. Page number 25, my lord. Paragraph number 25, my lord, page number 107.
I've carefully shifted the evidence on the court,
During the submissions,
considering the submission of the learned counsel and the line of the action, I've come to the conclusion that the dismissal of the year is not just. Right beside the issue number 4 in this one.
before that, my lord, the representations were discussed, the submissions, the recording were, oral submissions were recorded, and those were written, my lord, and thereafter, my lord, the submissions made by the parties were recorded, and if only this much was given, my lord. And the judgments relied upon are only for the purpose of compensation, my lord. So my compass prior member to look at maybe 100 share, my lord. Because if we go by the case, my lord, there are two references earlier, there was another reference, my lord, where the issue was, he was not given salary for a particular postman. He ended the service. And in that case, well, some departmental proceeding was also drawn, my lord. And according to, after the inquiry, it was decided that some action will be taken regarding his termination. And there's, because the reference case was pending, my lord, petition under 33(2)B was filed.
and it was taken care of by the London Industrial Tribunal matter. But when evidence was taken from the management side, but
My lord, the award under second is 20 March 2018, madam. This award is under second.
but the issue is the termination.
That is what I'm reading, page 78.
Issue
And the 5 lakhs has been made to the workman, madam. That is the case.
Isn't this
Because there is
award
no
on the
connection
page
with the
level
other-
reference? Whether was justified in dismissing the workman?
Yes.
That's the terms of reference at page 79.
Yes. This issue was taken up during the course of the earlier round of litigation, the earlier round of reference matter. And the inquiry was conducted, domestic inquiry was conducted, and one miscase was filed. And that was taken care of by the industrial tribunal matter, and the evidence was held by the management side. But what happened, my lord, that reference case was at the initial stage. That reference case, your lord, was decided holding that the management, it is not a case comes under industrial disputes matter because it was a hospital. So accordingly, it was disposed of. And this case was also decided holding that there is no jurisdiction that lies with the industrial tribunal. So this case was closed matter, holding that there is no authority to approve or dismiss the player. I can place the order. Ma'am. And if the irregularities were found, my lord, then he admitted that he had done something wrong and he wanted to return back the money.
Prior portion is at page 35.
Then there is no reason. Nothing.
I will take a look to 35, they are prior mine. They will challenge the award dated 20.
That is what I'm looking. There's no reason.
The direction is the page 107. ma'am.
Yeah.
That is the direction for paying.
And you see paragraph number 25. All these are putting, he has mentioned first, what is the tax? Then he has mentioned the evidence. Then he has mentioned what is the submission. What are the judgments? Then paragraph 3. In fact, I'm sorry that this matter should for 8 years. Problem is, if it was any other matter, I could have exercised a jurisdiction by myself to decide this issue. I can't do so because the labor court matter has to be decided by them.
That is why I said it, that they also another had no reason, and that was to go across it. There was a directive to look into it as to whether about some service condition out there, he's right or he's right and all. Immediately said. In that case, there is absolutely nothing. Yeah, so Madam kindly see paragraph 25. See, it is just what Mr. Mishra was submitting, I didn't hear anything. It was just dancing to single word. These are all quotations that he has made and all, and then I will be 25. He is direct to dispose of the matter with his feelings. Never heard Mr. M.K. Mishra, the counsel appearing on behalf of the petitioner. He virtually appears on behalf of the petitioner, on behalf of the respondent number 2. Respondent number 2. At the outset, this court, at the outset, this court strikes out the name of the respondent number 1. In as much as it is a well-settled principle of law that when an officer in exercise of the judicial powers passes an order or an award, the officer cannot be made a party in a proceedings. In fact, the Supreme Court in this regard have in various orders have deprecated such practice. Next. The present petition has been filed assailing the award dated 23/2018. Passed in reference case number 3/2016 by the learned presiding officer, Labour Court, Dibrugarh. It is very pertinent to take note of that by the notification dated 12/2/2016, the government of Assam had referred the same dispute. State had referred an industrial dispute for decision of the learned Labour Court, Dibrugarh, by formulating the following terms of reference as would be seen in the schedule to the said notification. The terms of the reference are where, number 1, whether the management of Tata Referral Hospital and Research Center, Sabua, is justified in dismissing their workman, Sri Nobin Borua, with effect from 16/2/2006. Number 2, Roman, if not, whether the workman is entitled to reinstatement with full back wages or any other relief in lieu thereof. This board duly takes note of the award, impugn award so far. From a perusal of the said impugn award, it is seen that the learned Labour Court initially, the Labour Court have narrated the facts. Thereafter, referred to the evidence the arguments placed by both sides, along with the judgments rendered by various courts. This aspect can be seen from a perusal of paragraph number 1 to paragraph number 24 of the said award. It is further seen that the decisions, so
rendered by the learned labor court can, it's apparent from, the decision so rendered by the learned labor court can be seen at paragraph number 25 and 26 of the award, which is reproduced here in below, 807. From a perusal of the above quoted paragraph of the impugned award dated 23/2018, it would be seen that the learned labor court did not decide anything, did not assign any reason for deciding, for opining in reference as regards the terms of the reference. It is the opinion of this court that the learned labor court was under a statutory obligation asked upon the court, asked by the Industrial Disputes Act 1947 to have decided the reference so made by the notification dated 12/2/2016 by assigning reasons. It is well settled that when any order or award passed by a statutory authority, any judicial order is passed by a statutory authority, it is the requirement of law that it has to be accompanied by reasons. The impugned award, as stated above, is bereft of any reasons. Considering the above, this court therefore sets aside the award dated 23/2018 passed by the learned labor court, Disciplinary. It is also the opinion of this court that the reference so made by the appropriate government has also to be answered by the learned labor court. Accordingly, the instant petition therefore stands disposed of with the following observations and directions. The impugned award dated 23/2018 is set aside and quashed. Number two, the learned labor court, Disciplinary, is directed to decide the reference, the terms of the reference, being reference case number 3/2016. On the basis of the terms of reference notified in the schedule, the notification dated 12/2016, by assigning due reasons. Number two, three. This court also takes note of that the respondent herein, that the workman in question was dismissed on 6/2/2006, and 2 decades in the meantime have passed by. Under such circumstances, this court therefore directs the learned labor court, Disciplinary, to decide the said reference upon the appearance of the parties as expeditiously as possible, taking into account there would be no further necessity of any evidence to be led except hearing the arguments of the respective councils or of the respective parties. Taking into account that the parties are duly represented before this court today, this matter, this court direct the parties to appear before the learned Labour Court, Dibrugarh, on 24th of June 2026. The registry is directed to, or is that, 40 directed to send back the records to the learned Labour Court, Dibrugarh, ensuring that the said records are available with, are ensuring that the same records are available with the learned Labour Court on the date next fixed by this court hearing above. If necessary, the registry of the Gauhati of the court shall employ the services of a special machine. That these matters should have been, the bench for very sad about the legal court matters. I'm taking the new matter that you it doesn't matter, it's a small issue, could have been finished off in 2018. Isn't it? Mr. Sharma, tell me, what is your case?
Page the last.
What last name?
What is case?
Huh?
My lord, case of the petitioner is, my lord, he was settled a Keystone query for the period 2011, 23/7, 2011, 22/7, 2016 under Assam Minor Mineral Concession Rules 1994. He has successfully executed the that is the stone query.
So, but
Made all the case.
have been initiated.
My lord, Bakija initially. We are agreed by this, my lord. This is the order, my lord. Lordship may kindly see page 73. Okay. Page 73, my lord. The next argument.
Pass some orders in this type of matters. You have only done those matters. This is pertaining to the fund, huh?
MMDR fund.
MMDR.
Pass some orders. You have only appeared in those matters, I remember. Some matters are dismissed. There were two amounts. One is MMDR fund and there is another amount.
DMFT, madam. DMFT.
Where?
Yes.
I
DMFT.
passed orders to the field.
One of
And it wasn't with the case of the council.
one of the case I appeared, my lord. That case is still pending, my lord. That is DMFT, my lord.
That is one party is pending, the other one is.
On other party, I would.
You withdrew the MMDR.
Yes, correct, my.
Now what are you challenging here?
My lord, here in this case, my lord, lordship may kindly see the 79. My learned friend will.
79. Your lordship, for the MMC rules.
About the MMDR.
Yes, that's MMDR what rules. He's saying that since I entered into agreement prior to this commencement of this rule, 1994. So there is no provision to deposit 10% of MMDR fund, your lordship. So basically his case is that.
That is.
So he's saying that I have already paid some amount, 10% of the MMDR fund, which we are demanding from him. After the commencement of 13, he said, I'm not liable to pay this. But Rule 79 repeals and saving clauses there, lordship. It says that the Assam Mine Concession 1994 as amended from time to time in the application to the state of Assam and hereby repeal. Clause 2, notwithstanding such repeal, anything done or any action taken or proceeding commenced under the Assam Minor Mineral Concession Rule 1994 as amended from time to time shall be deemed to have been done, taken or commenced under this rule. Provided whatever terms and conditions of any minor concession granted before the commencement of this rule are inconsistent with or repugnant to this rule, the same shall be deemed to have been modified in accordance with this rule from date of notification thereof. So, as per this rule, since his agreement was from 2011 to 2016, 2013, this rule came into play. In this rule, they say that MMDR, 10% MMDR, they have to deposit. Now he's covered by this rule 79. He's saying that no, since I had executed agreement 2000.
No, that matter I have already dealt with and he has withdrawn that.
No,
MMD.
that is a different matter, madam.
MMD.
That's a different matter.
That is a different matter.
I pass orders in.
They have been saying,
Who was there or you were there.
checking that most of, if I know, the MMDR fund, whether they have to deposit or not. That was the issue.
I have deposited DMFT MMDR.
You want.
I refund, madam.
They wanted refund.
And your lordship has passed another order.
He gave up MMDR.
They gave up MMDR.
Okay, madam.
But now here
And
is,
that MMDR he has given up. Why I'm saying he, see. Earlier I passed another order.
Yes,
Where
yes.
I say that MMDR you have to pay. Taking into account that and the particular rule of
yes,
MMDR.
rule thereof.
I said you have to pay. Then the second petition came up where he was appealing. Then I said, no, MMDR you have to give. Then he said that EMFD or AR, that is not required. So he gave up MMDR and left only that, and that matter is still pending.
District Ministerial Complete Fund.
But that is, what is that? Okay. You pay interest, sir.
My lord, I have to. My lord,
Pay interest. We dismiss with interest.
I'll let it go.
12%.
my lord.
Payment of interest 12%.
Please, my lord.
Huh?
Lordship will kindly consider that, my lord.
What? No, if we dismiss it,
I will get
I is not entitled to interest.
already Baki proceeding is there, my lord. That will be followed. I will leave
So what should I do? Dismiss?
this, my lord. Actually, I had gone for one last order, my lord. I have one decision of the Honorable Supreme Court. I did not find any merit, my lord, in that case. That is why, my lord.
What does it say?
Bongsi door.
What does it say?
My lord, when there is this 79, specifically stated last paragraph, my lord.
Show me, let me.
Yes,
follow
ma'am.
that.
Okay, ma'am. Thank you. Paragraph 21 and 20.
Heard Mr. G. Sharma, the learned counsel appearing on behalf of the petitioner. Mr. R.R. Gopal, the learned appearing on behalf of the Forest Department of the Government of Assam. The present petition has been filed by the petitioner challenging the application dated 28/2018 passed by the Divisional Forest Officer Dhubri Division, thereby requesting the petitioner to make payment of the outstanding amount of ₹6,05,502 on or before 15/10/2018. It is the specific case of the petitioner that the petitioner was granted the contract settlement for a period of 5 years with effect from 22/7/2011 to 21/7/2016. Under such circumstances, the petitioner cannot be made liable to pay that. What is that fund name? So and so fund. For short, MMDR fund. In terms with Rule 59 of the Assam Minor Minerals Concession Rules 2013, inasmuch as the said rule came subsequent to the grant of the contract settlement in favor of the petitioner. In opinion of this court, the said submission appears to be misconceived, taking into account Rule 79 of the rules of 2013, which specifically refers, mentions that
Page 291.
It specifically mentioned at in the proviso to rules 79(2) to the effect that wherever the terms and conditions of any mineral concession granted before the commencement of the rules of 2013 are inconsistent with or repugnant to the rules of 2013, the same shall be deemed to have been modified in accordance with the rules of 2013 from the date of notification thereof. So taking into account the above, comma, the non-mentioning of the requirement for payment of the MMDR fund, the amount towards the MMDR fund in the settlement made in favor of the petitioner would stand modified by the proviso to Rule 79(2) of the rules of 2013, thereby including the requirement in terms with Rule 59 of the rules of 2013. Taking into account the above, this court therefore does not find any good ground for interfering with the impugned order dated, impugned communication dated 28/2018, which have accordingly the writ petition stands dismissed. Interim order passed earlier stands vacated. Okay. Thank you. Follow hospital.
My senior is stuck in some other court, so kindly, Ashish Das Gupta, sir.
Senior.
Ashish Das Gupta, sir.
Election court number 3. Your senior is also outside. You appear for the workman. You appear for the workman.
Yes.
You don't know.
File. Right.
Huh?
I have no file. Someone said told me that I'm releasing code number 3. So that's why I'm instructed. He instructed me that told that they are
You also don't have file.
No, sir, I have my file.
Are you? By the time your senior comes, it may get dismissed. Particularly. Counsel appearing on behalf of the party fixed for importation. This the matter again on 11th of June, no, 4th of June 2026.